Welcome to our deep dive into one of the most critical legal battles of our time, forced labor and private detention, specifically the Menocal versus GEO Group case. Imagine working a full day, maintaining a massive facility, cleaning, cooking, doing laundry, and earning just $1. Or sometimes, nothing at all. This is the heart of the massive legal battle we are covering. This isn't history. It's the center of a legal controversy happening right now in the United States, raising critical questions about labor and human rights in private detention centers. In private immigration detention centers, a controversial practice has persisted for years, known as the, quote, informal policy of mandatory maintenance work. Detainees allege they are forced to perform facility maintenance, such as cleaning, cooking, and doing laundry, for merely pennies a day, sometimes receiving nothing at all. They claim this labor is coerced under the threat of punishment, like solitary confinement. While detainees call it forced labor, the private companies refer to it as a, quote, voluntary work program. This conflict exploded in Menocal versus GEO Group, a landmark class action lawsuit that brought these practices into the legal spotlight. The lawsuit was filed by detainees at the Aurora Processing Center in Colorado, targeting one of the largest private prison contractors, GEO Group. The core of the claim is that GEO Group violated the Federal Trafficking Victims Protection Act by coercing detainees into labor, essentially using them to run the prison for cheap. GEO Group's defense strategy hinges on a potent legal shield known as, quote, derivative sovereign immunity. They claim they cannot be sued because they were operating on behalf of the federal government, essentially arguing, we were just following orders from ICE. By asserting this immunity, GEO Group is attempting to use a procedural defense to stop the lawsuit before it ever gets to a full jury trial. But the courts have pushed back, ruling that ICE never specifically mandated the company to pay only $1 or threaten detainees, leading the case to the U.S. Supreme Court. As of late 2025 and early 2026, the Supreme Court has heard oral arguments on this pivotal case. The justices are deciding a critical procedural question. Can private companies use this immunity shield to immediately stop these lawsuits, or must they face a jury trial first to determine the facts? We are now awaiting the final ruling from the Supreme Court, which could arrive at any moment. If the Supreme Court rules against GEO Group, this decade-long battle will finally go to trial, potentially dismantling the core business model of private detention forever. Stay tuned for immediate coverage as we await the final ruling that will determine the future of labor in private detention centers. Subscribe to our channel for the latest news.